Thank you, students, for tuning in our channel, African Dignity. We hope that you have grasped what I posted before this video, because it was just an overview to make sure that we are in the same wavelength and you understand what is this module about. This is a very important module that you are going to be dealing with as long as you are a lawyer. Well, as long as you are practicing law, you will need to know your rules around law of evidence. Law of evidence is very important. We will use law of evidence in your criminal procedure, in your civil procedure, in your even when you are doing divorce matters, you will need criminal procedure. And another important aspect is that all of you has to be conversant with what is called the Plascon-Evans Rule. Everybody should know what is meant by Plascon-Evans, because when you go for your interviews in your whole life, when it comes to legal appointments, you will be asked a question on Plascon-Evans Rule. I was so embarrassed when I saw a magistrate applying to be a judge just recently, and she was asked this question, that what do you understand about Plascon-Evans Rule? And she said, it's the first time that I'm hearing. I don't know what is it. And it's embarrassing. I don't want to see a student from UniZulu going for an interview and he or she is asked a question around the Plascon-Evans Rule. Plascon-Evans Rule, let me give it to you now. This concept of Plascon-Evans Rule simply says, when factual disputes arise, therefore relief should be granted only if the facts stated by the respondent, right, together with admitted facts in the applicant's affidavits, justify the order. So if you read to this case, the Plascon-Evans case, it will tell you that it is entirely dependent on the discretion of the court when the court has read both submissions from the applicant and the respondent. What is important is that the Plascon-Evans Rule is mostly used during what is called motions court. Motions court is where the court has to gauge whether there is prima facie case, and then the case will then be given what is known as the usual order, right? What do we mean by the usual order? The usual order will say, oh, okay, your matter is postponed to such and such a day so that you can finish your pleadings, and it might go for hearing. It must go for a trial or hearing in a particular court, because the motions court is that court where all the cases are first introduced in court, and they would see if everything is in place. Because what is important in the motions court is that the court has to determine whether that particular case is trial ready, right? For instance, the court might use the Plascon-Evans Rule where somebody applies for an order that will repossess a vehicle. But the respondent might say, no, the court should not grant this order because the applicant has committed what is known as irresponsible lending. Irresponsible lending would be where a bank borrows your client money, and your client tells the bank upfront that I am not working, but if you allow me to, if you give me money, I will go and buy a vehicle, and I will use that vehicle to convey stuff from Mondi, and out of that money I will get about 10,000 rand. Out of the 10,000 rand, then I will use the 4,000 rand to pay installment together with insurance. And they agree, they sign the agreement, money is given to your client. But the National Credit Act doesn't allow that. You cannot do what is called irresponsible lending. So if now the bank turns around and says, no, I'm going to repossess the car because you have failed to pay, your client has a right to refuse and say, this was irresponsible lending, so you must give me time, and I will keep on paying, especially if there is evidence that your client has been paying or something came up. Remember there was a time when there was COVID, people couldn't pay installments. So people used that excuse to say it was COVID, so you cannot force me to pay because COVID was known as a national disaster, and people could not be evicted from their houses, and people were not even allowed to go to court because there was something called lockdown. So people use that as an excuse. There will be another excuse during your times as well. So you can use that to rebut evidence that says you have failed to pay, and you then rebut by raising evidence that says the applicant was irresponsible in lending, right? So also another case you need to read that agrees with the Plascon-Evans Rule is the case of Stellenbosch Farmers Wineries Group Ltd and another versus Mattel and Mattel HCA and others, right? There again, the court used the discretion, the similar effects as in the Plascon-Evans Rule. So you must know this. I don't want the situation where you go for an interview and say, no, I've never heard of this. It's the first time I'm hearing it. You will get this question when you go for an interview as a magistrate, as an article clerk, as a judge. You will get this. This was a question that was asked for people who wanted to be presiding officers at the Constitutional Court. So they were going to be justices at the Constitutional Court. So it's important for you to know the Plascon-Evans Rule. So you must read the Plascon-Evans case together with the Stellenbosch Wineries case. You read those cases, then you will know exactly what is meant by this rule. And what it simply says is that it will be the discretion of the presiding officer to say once they have read both submissions, then they can make a ruling against or in favor of the other party. Right. I understand now that you have done up to week 9, which is the 6th topic of your studies in the law of evidence. Now we come to week 10, which is topic number 7. Topic number 7 of your study, which is simply it's simple. One thing and one thing only. It is simple, one thing and one thing only. Oh, let me take this call. Oh my God. Hello, Fikile Munjan. I'm sorry about that. Hey, these phones keep on bothering me when I'm busy with the class. Okay, so we have spoken about what you did up to lesson 6. So we will start by doing lesson 7, right? Lesson 7 deals with what is known as privilege. Okay, deals with privilege. So let us tackle now the concept of privilege. What do you mean by privilege when, as far as evidence is concerned, right? There is evidence that is termed privilege. What is important is that you should know that there are two types of privileged evidence. There is what is known as state privilege and private privilege. So for the purposes of this lesson, let us start with privilege in as far as private privilege is concerned. Okay. When dealing with the private privilege, the book that was recommended to you, I think it was Zeffert, but I have recommended a book by Zeffert and Pies, right? If it's a third edition, and the title of the book is The South African Law of Evidence, third edition. The authors are D.T. Zeffert and A.P. Pies, right? It's published by Nexus. So you go to that book and you turn to page 621 of that book. If you go to the library, you borrow the book, I think it will be there. Third edition, and you turn to page 621, and the topic there will be privilege. So you will read a lot about privilege. So for now, I'm just going to give you an overview of what do we mean by privilege, right? And also, at the end of this lecture, you must be able to distinguish between the different forms of privilege, that would be being private privilege and state privilege. And also, you must also be able to differentiate between a competent witness and a compellable witness. What is meant by a competent witness and a compellable witness, and able to present an argument for why that witness falls in that particular category. Why do you say this witness is compellable? Why this witness say is competent? And also, you must be able to critically discuss the privilege against what is known as self-incriminating evidence. Self-incriminating evidence is protected by Section 35, subsection 1A of the Constitution, that is now the 1996 Constitution Act 108, right? It is protected with that, and also Section 203 and Section 219, capital A of the Criminal Procedure Act, right? Those are sections that deal with self-incriminating evidence. So Section 35, subsection 1A. So A just says the right to silence, right? A right to be silent. Okay. In America, they call this the Fifth Amendment. And if you want to remember very well, somebody who once used it here in South Africa was when there was a Zondo Commission, and there was a lady there in the Zondo Commission who was called to give evidence about her dealings with the SAA and her dealings, with the SAA, and during the time when she was a board member of one of the municipalities in Richards Bay, or in Pangan, if you like, in Mhlatuzo water board. She was once a board member there, and she was called to the Zondo Commission because there were allegations of malfeasance against her, and she invoked that section, right? In America, you say you'll be asked a question, and for every question that you've been asked, you will invoke what is called in America the Fifth Amendment. But in South Africa, we don't say Fifth Amendment, because in South Africa we don't have the Fifth Amendment. But what do we have? In South Africa, we have what is known as Section 35, subsection 1 of the South African Constitution, which grants any accused person a right to be silent. That means you don't have to answer any questions, you invoke that right. Your client has a right to invoke Section 35, subsection 1A of the Constitution that says, I invoke my right to remain silent. Or you can say, I invoke my right in terms of Section 35, subsection 1A of the Constitution. Also, to go further and explore more information about your right to silence, you can also read the case of Ferreira versus Levin, NO, and another, and also read the case of Frey Henhoek and other versus Powell, NO, and others. The case, the citation of the case there is 1996, volume 1, SA at page 984. It's a constitutional court case, so it's very important to read that, and especially for the purpose of this right to silence, or the Section 35, subsection 1 of the Constitution right. You read, in that case, you read at paragraph 96. And also there is another case, is the case of Masokanye versus Additional Magistrate Stellenbosch and others. It's the citation of the case is 1994, volume 1, SACR at page 21. It's a Cape Province case. So you read that, and also it's also important that these privileges, right, this privilege is, you make sure that it does not allow your client to do what? To self-incriminate. Self-incriminate is to say, make a statement that is going to put yourself in jeopardy. So also you can also look at Section 35, subsection 3 of the Constitution, about the same thing, the right to not to incriminate yourself, right? That you must be warned. Your client has to be warned by the arresting officer that he has a right to be silent, right to representation by an attorney of his choice, and he also has a right not to make confession or make an admission that will incriminate him, right? So also, the purpose of this lesson, right, is also to empower you to be able to present arguments based on the rationale of privilege against self-incrimination. Is to say why is it important that a person should not incriminate himself? What is the rationale behind the concept of self-incrimination, right? And also you must be able to present views as to whether it is necessary to advise a person of the right in terms of Section 35 of the Constitution, especially at pre-trial stage. Now, there is another one where, say for instance, your client is asked to go for what is called identification parade, right? Now, there is an argument whether it is necessary for an attorney to be present while your client is going for what is known as identification parade. And the truth is, there is no need, because your presence is not going to change anything. Your client will be stood with other people, and the complainant will come and point, or the witness will come and point at your client or anybody else, and your presence can only ensure that the ID parade was legally made. Because you can imagine where your client is black and he is at the identification parade with whites only. Obviously, the person who has been aggrieved or who is the complainant will know that the person who broke into my house was black. So there's no way he can point white people. He'll point the only black that is there. Sometimes the rules are that the people in the identification parade should be of the same size, and they must wear clothes that are similar. It's okay if maybe they're in prison, then they are given this clothes. There is this blue, there's orange overalls. There's also blue overalls that are worn by awaiting trial prisoners. Maybe you can, your client can advise your client that when he goes for this parade, he must ask that they should all wear those awaiting trial prisoners clothes, and the people who will be participating in the identification parade should be people of the same height, maybe of the same age as well. You can imagine if your client is put on an identification parade with old men and is the only one who's young, then the person will just go and point at the young person, you see. So they should be of the same size, so that there are no complaints as to say he was, let's say your client has got a scar. The IO must look for people with scars, so that he's not identified by this big scar on his face, because the IO will say go and point at the person with a big scar on the right hand side of his face. So it should be, it must be things like that. That at that identification parade, the people have got similar features, same age and same height, and they should be of the same race, preferable, because if it's not, then there is a problem. So you must be able to present views to whether it is necessary to advise a person in his who is going for ID parade in terms of Section 35. So it is important. And other cases that you can read in order to get more insight into this topic is the case of S versus Luane, right? And also the case of Maunye. Maunye will be M-A-U-N-Y-E. It's a 2002 case, volume 1, SACR at page 266. It's a Transvaal case, right? So it is important to advise your client at the pre-trial stage to be careful. Your presence is not is not necessary, right? There's also you must read the section 35 subsection 5, that is now the exclusionary rule, because if that evidence was obtained in a manner in which it is not fair to your accused, that evidence you can fight for that evidence to be excluded. So that's why the exclusionary rule in terms of section 35 subsection 5 of the Constitution kicks in. You can also see the case of S versus Marx 1996-2 SACR at page 140. You can also see the case of Matebula and Huma, also the case of Mapumu 1996 volume 2 SACR at page 84. So you can look at that as well. I have stated that during the bail hearings, you can allow that hearsay evidence be led, right? And also there is something called that we did in class during our criminal procedure class, what is known as the plea bargain in terms of section 105 capital A of the criminal procedure, where you will draft a plea, and in that plea you will be admitting what your client did, and you will even recommend what sentence he has to be given in that plea. But now that plea is actually evidence, because it has to be handed in as evidence that your client indeed made that statement, and that statement was tested in court, confirmed by the presiding officer. But now here is the catch. Let us say now your client has already made that statement, and the presiding officer says no, I am not satisfied with the sentence that he has been meted against your client, and I'm not satisfied with the admissions that have made. Your client has not pleaded guilty to all the elements of the crime, because what is important when you do a plea bargain, and when you do your section 112, you must plead guilty to all the elements of the crime. Otherwise, the presiding officer is not going to accept that. So what happens when that plea is not accepted? Can now, and then it's not accepted because there was a plea bargain to say, if your your client pleads guilty to that crime, he's going to be given a lesser sentence. Now, here we are where the presiding officer says, no, I'm not budging. Let us do a normal trial. And then your client decides to plead not guilty, because there are chances of him getting discharged from the case. So he then decides to plead not guilty. Now, can that statement, 105 statement of that, or 112 plea, can it be used against your client, because he's the one who made it, and it was read in the record in court, but it was rejected? Can it be used? No, it is also privileged. You cannot use it in the other trial, because once that plea is rejected, then that means the case has to start de novo in front of another presiding officer. So you can't use the information that's contained in those pleas in order to enforce your argument or prove that the accused is guilty, because it becomes privileged. So that all falls under private privilege. There is also something called legal professional privilege. That is now, legal professional privilege is where a doctor cannot divulge information between him and his client. An attorney, an advocate, cannot divulge information, cannot go to court and say, I'm going to testify against against the accused because he was once my client and he told me that he was thinking of killing his wife. Will I be able to represent him if he is now arrested? You cannot, as a professional, do that because you fall under that private privilege. Okay. Also, evidence that can be led by a wife against the husband, that also is privileged, including, it's called marital privilege, right? It's called marital privilege. And there is also what is called parent-child privilege. You can't go and testify against your child, or you cannot be forced to go and testify against your child that your child is a thief or he's done something, or you cannot do it because of you'll be allowed to use that parent-child privilege. Although you were there, you saw what your child did, but you can be excused for not admitting to go and lead evidence against your child. There is also something called state privilege, right? Where I have touched on this when we were glossing over what we have done with the Dr. Naito. State privilege, there is something called classified information. Classified information is information that is kept by the state. It is so sensitive that if it can be out there in the open for public consumption, a war might break up between the country, your country, your country and other nations. So that is what is called state privilege. And there's also something called diplomatic immunity. So people who are diplomats, that is now people who are, say, ambassadors, right? An ambassador in South Africa from China commits a crime, kills a person, he is under what is called state privilege. He cannot divulge that because he falls under the immunity principle. Right. Also, another one will be a situation where state privilege, there will be a situation where a president has to give evidence. You remember when MPs, cabinet ministers, president, deputy president, or even judges, when they are sworn into office, they are part of what they swear in that oath is to say, I will not divulge sensitive information about the Republic. So those are what is called state privilege, right? And then the cases that you can read, you can also read Section 202 of the Criminal Procedure Act 51 of 1977, and also read Section 42 of the Civil Proceedings Evidence Act 25 of 1965, right? You can read that, or you can also read the Amendment Act 45 of 1988, right? The Law of Evidence Amendment Act, okay? And also read the case of Van der Linde versus Khalid. The citation is 1964, volume 2 SA at 239, right? Right. there you'll be dealing with what is called the detection of crime. How does privilege help detection of crime? You will be answering that question. And also you can read the case of R versus Abelson. It's 1933 TPD at page 227. You'll get that law report in the library. Or maybe you can also use Google to Google that case, R versus Abelson, 1933 TPD 227. It will tell you about whether, at what stage can somebody get information from the police, from a docket which is kept by the police. Okay, before I forget, also in the private privilege, there is something called the POPI Act. The POPI Act. POPI Act will be private personal information, prevention of private. Yeah, but the POPI, just read the POPI Act. It will also does not allow people to do what, to divulge information about you against your will. As I've seen people, when you see people fighting and then you go and take a video, and that video you flight it and it's seen by the police. The police will use that video to do what? To arrest people and even convict people. That is not allowed. You are actually breaking the law if you do that. You're not supposed to do that, right? You are not supposed to divulge information. You can be charged for doing that, because that's where now when we deal with cybercrime, that is now electronic evidence, because it becomes electronic evidence. Can you then give that evidence to anyone without the consent of the person that are in that video? You cannot do that. But also you must read another act, which is the Promotion of Access to Information Act number 2 of 2001, right? Although that act is not very important for the purposes of assessment and test, but you need to read that act, access to information, including the POPI Act. Okay. Now, I was still saying, in a police docket, you need to know when can that information be given to the accused. That is very important, because as an article clerk, you'll be going to court, and you will see that one of the requirements is that the prosecutor must give all the information. They will actually make a copy of the whole docket, everything that's contained in that docket. They'll make copies and give it to your client so that you'll be able to prepare your defense. Now the question is, when do you do that? Can you do it at any time? Let's say somebody goes now today, opens a docket and make a statement implicating your client. Can you go tomorrow and say you want copies of that evidence that is contained in that docket? No, you can't do that. It's because it is privilege, state privilege. So why is it privilege? The reason is that the police are still busy with their investigation. If you are given that information and there are names that have been mentioned in that statement, you may go and alert those people to say, do not cooperate with the police. In that way, you are doing what? You are interfering with investigation. So that information will be privileged. You are not allowed. But once the public prosecutor declares that now, your worship, investigation are over, the matter is trial ready, that's the only then you can be given statements from that docket. You need to know that. Okay, now let us deal with something called hearsay evidence. I have made a video, my previous video, where I gave you the correct definition. I'm stressing this, that it is very important that when you are defining hearsay evidence, you need to give a thorough definition. Don't just go cut corners or just do shortcuts when you're giving that definition. You need to say in terms of the Law of Evidence Amendment Act 45 of 1988 in section 3 subsection 4, hearsay evidence is defined as evidence. The probable value, the probative value of depends on the person other than the person that is giving that evidence. You must give that full definition, even if you go for when you go for your interviews, whether you are being interviewed to be a judge, to be an article clerk, you will give that long and precise definition of the hearsay evidence definition. Then if there's two of you and there's two guys who go for interviews, and you go there and you do a shortcut, there's a likelihood that you may not be taken, you may not be employed, because you gave a short definition, whereas your counterpart with whom you want to be employed in this post went to page 404 of that Zeffert and Pies book, right, and gave the definition as it appears there, where it says hearsay evidence will be in terms of section 3 subsection 4 of the Law of Evidence Amendment Act 45 of 1988 is described as evidence, whether oral or in writing, the probative value of which depends upon the credibility of any person other than the person giving such evidence. So if you describe it like that, then you can be sure that whoever comes to do that another definition will fall short. They will choose you instead of choosing the other person. So it's important that when you do you answer a question about hearsay evidence, you give that definition, even if it's not asked. If you say, what is hearsay evidence, you will give that definition. So what do you understand by hearsay evidence? You will give that definition, and I can assure you, if I don't give you a full mark, or Dr. Knight doesn't give full mark, you must come and ask us, why didn't you give a full mark when I have answered hearsay evidence, like how Advocate Sobon said we should answer it. So what is important with hearsay evidence is that it is evidence, whether oral or in writing. The probative value of depends on the person who actually made the actual evidence, not the one who heard somebody saying, I heard that Mr. So-and-so was killed by Sipo. The credibility of that evidence will depend on that person coming to court and confirming it. So I think you've got that clear. The case you can read is S versus Ndlovu. Citation is 2002, volume 2, SACR at page 325. It's a Supreme Court of Appeal case, so that case is very important. It will tell you exactly. Okay, and also go and read that section 3, subsection 1 of the Act, which is Act 45 of 1988. That is now the Law of Evidence Amendment Act, right? You will see that it sets out section 6, what is called exceptional circumstances under which hearsay evidence may become admissible. Like I've told you, that in the case of bail application, it can. There's also another hot issue that is still in limbo. Is now whether somebody makes an affidavit, a sworn statement, before a police officer, and that person dies. So we've said hearsay evidence is a written evidence, right? And the credibility of that, or the probative value of that statement depends on the credibility of the person who made it. Now the question is, if a person makes an affidavit, that is now a sworn statement, in front of a policeman, and the person dies, can that evidence be admissible? Because it is hearsay evidence. So I wanted to go and read that, and I'm sure if you do that, then we will have a vibrant class when we meet again. I'm sure for now, let us leave it there. I hope everybody understands. If you don't understand, you will contact your class reps, then they will send me questions, what you didn't understand about these classes, because I want everybody to be on the same page. You must know exactly. Now, especially when we are dealing with types of evidence, you must know what we mean by an opinion evidence, what is oral evidence, what is direct evidence, what is electronic evidence, what is circumstantial evidence, right? You must know those types of evidence. Thank you.